We Will was founded 7 years ago to help women and children get involved in legislation. It seems as though since we're all living in Trump's America, more folks are engaging than ever before. And so fast forward, We Will has close to 7,000 members, and we host about a dozen events a month. And for this particular event, we've teamed up with some amazing organizations. I'm really excited for everyone to get the opportunity to hear from some of our community leaders from the organizations. We have local favorites like the DPOE, the Democratic Party of Evanston, the Evanston Chamber, as well as Indivisible Evanston. And we have some more of the statewide organizations like Illinois Democratic Women and She Votes Illinois. And it's going to be a really great time hearing from everyone. The NAACP is here, and we have some fantastic questions for our candidates. The Illinois Supreme Court is one of the most important things on the ballot, which is why we're hosting this event. And I'm excited to introduce my commissioner, Larry Suffredin, who does wonderful things here in Cook County, but also is a friend and a mentor to many of us here in the room. And he's going to help all of us a little bit. One of the biggest things that I've learned at We Will is that not everyone knows what's going on, and sometimes we end up in rooms and in conversations where we don't always understand. And so we're really about that education component. So Larry, come on up here. Tell us a little bit more about the Illinois Supreme Court and what they do, and thank you for being here with us.
Thank you, everyone. I'm glad to see this crowd here. You know, judicial elections are at the end of our ballot, and unfortunately, the fall off on judicial elections is great. This is one of the most important elections that's on the ballot, if not the most important, because the Illinois Supreme Court is the ultimate court in this state. It is responsible for making final decisions on important legal matters. It also is responsible for overseeing the entire court system throughout this state, the appellate court, the circuit courts, and the people running for this office are all extremely well qualified.
I'm really excited to introduce one of my new really good girlfriends, and that's Malika Gardner. She's an amazing woman. She's the founder of Evanston Live TV, so you might see her popping up in your Facebook feed. And if you're a local friend and fan, you get to see her interviewing all sorts of amazing people in our community and throughout Illinois. I'm also really proud that this year she's working with We Will and has written her first piece of legislation that we're running this session, and we're working side by side with Representative Ford on a piece of legislation that will expand Black history education. And at a time where many people's histories are being erased, this particular effort is really fantastic. Without further ado, my friend Malika Gardner of Evanston Live TV.
Thank you all so much for coming out tonight. You could have been anywhere, and you came here to get some information, so thank you for your time. And I want to give it back to Alexandra. I just came aboard We Will. I had some ideas. Can everyone see me, hear me back there? I had some ideas that I wanted for the community, the Black community, and I joined their board and laid out, I have a ton of ideas, so you're going to see a ton of bills getting pushed out there. And so the first one we're tackling is the one that she's talking about. So you all be sure to look that up and support it. But I want to thank Alexandra so much because she has really taught me the ropes. I was new to the whole writing legislation and how it all worked. She took me to the Capitol, to the Black Caucus last week, and it was intense. I don't know how you all do it, like with the elections and all of that, it's intense, but it's all about making change. So the reason that we're doing this event today is because I have learned so much about the power of voting and how important this race is. I would like for you to take each a minute to just give us a little more intro into you before we move on to the next question. We could start with House. Justice House?
My name is Nathaniel Roosevelt. I'm Nathaniel Roosevelt House. I have 43 years of legal experience, including 21 years as a judge. The Bar Association has found me highly recommended, highly qualified, at least qualified. And I believe that people, in addition to qualifications, should look at the perspective of a judge. Because really, in many cases, the outcome of a case depends on the judge's perspective. I was born in Tennessee and attended segregated schools. My parents came to Chicago to make a better life for us. And when we got here, my dad worked full-time for the city, and he wanted to be a lawyer, so he fulfilled his dream by going to law school at night. And I saw his struggle, and I followed in his footsteps. And I became a lawyer, and I represented the Harold Washington Party when that party was starting. I've never forgotten what it meant to be stepped on, to be treated as less than. But I'm proud to claim the endorsements of Congresswoman Jan Schakowsky, Secretary Jesse White. If you believe that a person who has my perspective belongs on the Supreme Court, I ask you just to remember 5 little words: House is in the house. Thank you.
My name is Daniel Epstein. I'm an Evanston native and resident. I live over by Sherman and Noyes. Grew up over by Evanston Hospital. And I'm an attorney. I served clients in the Supreme Court of the United States and in courts across the country. I worked for the #1 law firm for pro bono service in the country, Jenner & Block, and I won their pro bono award for service to the needy. I did appeals, post-convictions, criminal defense, civil rights, immigration, domestic violence orders of protection. That was the pro bono stuff. And then to keep the lights on, intellectual property, antitrust, commercial disputes. I was the former chair of the Chicago Bar Association Committee on Alternative Dispute Resolution. I co-authored the Illinois Civil Practice Guide that professors use to teach civil practice to their students. And I built an online court of arbitration that promoted access to legal remedy and protected against discrimination. And I got 10 seconds. But I'm proud that I'm endorsed by Alderwoman Simmons, Alderwoman Fleming, Clerk Devon Reed, Bill Stafford, Martha Burns, Donald Michelin, and Hecky Powell, just to name some of the Evanstonians.
Thank you. My name is Cynthia Cobbs, and I am a native, actually, of Baltimore, Maryland, just outside of Baltimore. So I got my early education in the public schools in Maryland. I went to a public high school. It was an integrated high school. Brown versus Board of Education had been decided, which meant that many of us were now in an integrated school. And some of us found it very, very difficult. In point of fact, my guidance counselor, even though I had completed college prep, suggested to me that I should not pursue a college education. Well, as you can see, I did not follow that directive and did pursue a college education, and beyond that, got a clinical social work degree, Master's of Social Work, from the University of Maryland. 10.5 to 12 years of my professional life was spent in the Maryland court system advocating for children who had been allegedly abused or neglected, either sexually or otherwise. That work in the Maryland court system developed in me an interest in the law, because more often than not, the judges whom I was presenting before did not have a clear or a complete understanding of childhood development or human dynamics. I ended up moving to Illinois, where I got my law degree and have been working in the Illinois court system for 31 years. Oh, I'm sorry, I didn't see you.
Sorry, I gotta wave bigger.
You can stand up.
It's really hard to summarize your life in a minute.
Yeah.
I have a website. It's called McBrideForSupremeCourt.com. I was very fortunate. I'm just going to tell you, I was born in Evanston too. But I grew up in a pretty nice family, so to speak. And the one thing that I was taught growing up is that you should treat every single person the way you want to be treated. You can read more about what I've done for 42 years in public service, but we've heard the word respect a couple of times today. I've been teaching, volunteering my time for over 35 years, teaching students, lawyers, and judges professionalism. And that at bottom, that is about respect. And what is respect? It's actually having regard for other people, for their feelings, for their rights, and their traditions. So that's my time is up, but that's who I am. Respect is for everyone.
The state government, the legislators, the executive, on some level, our political system here in Illinois has been plagued with corruption and seems to be broken or frustratingly divided. The citizens of this state have seen how our broken government has made it difficult to move forward on issues, i.e. Illinois pension crisis. Although people haven't described the judiciary system as being broken, but they have criticized the justice system as being unjust and have demanded for more restorative justice practices in the courtroom. Ultimately, a judge's responsibility is to analyze and interpret the law. However, restorative justice is more of an out-of-the-box thinking process that doesn't really focus on the law, but more so focuses on the rehabilitation of offenders through reconciliation, Hence, voting to confirm Brent Kavanaugh to the Supreme Court, Senator Jeff Flake used restorative justice reasonings by stating, the way that the justice works is that you recognize harm, you take responsibility for it, and then you begin to repair it. Therefore, are restorative justice practices applicable at the Supreme Court level? If so, what is your position on restorative justice and how may you use it in the Supreme Court cases?
Who would like to take that one first?
I guess I will. Turn this on. That's on. Okay. Well, first of all, the idea behind restorative justice is great. And the Illinois Supreme Court actually has already tried to implement it in the juvenile court primarily. And so there can be more done in terms of restorative justice beyond the juvenile court. But the Supreme Court itself can be actively involved if they get interested in essentially establishing alternative sentencing methods for people that are either incarcerated or actually won't be incarcerated through different programs. So there's a lot of ways the Supreme Court can get involved, but you know, I want to talk about the fact that when you say the system is broken, there are a lot of people that feel that the criminal justice system is broken because of the mass incarceration of many people from the African American community and the Hispanic community. And one thing that I have in terms of perspective is that I actually spent years in the criminal court. So I would be very active with the legislature because I think it's time to really change the mandatory sentencing structures that we have in Illinois. And judges can do that. And Supreme Court judges can go to the legislature, and someone like myself who has actually been there in the criminal justice system, I think I can be persuasive. And I think we need to really change our sentencing guidelines.
Thank you, good afternoon, and thank you for hosting us. And I am aware that this is a 2-minute question, and I don't think my answer is going to consume the entire 2 minutes. So, restorative justice has been around in the state of Illinois for a long, long time. It actually was commenced downstate in probably the 5th Judicial District. Prior to its implementation, we used to call a program that we utilize for alternative detentions issues for youth, JDAI. The Probation Services Division is housed in the Administrative Office of the Illinois Courts. And part and parcel of the Probation Services Division's work is work with juvenile offenders. So in the administrative office, there is a risk assessment tool that is utilized in all of our circuit courts to determine the level of risk for all juvenile offenders, in the interest of determining whether or not that youth is at risk to offend again, and to determine whether or not there are other services that might be better suited for a juvenile as opposed to incarceration, even in a juvenile detention center. So we have fewer juvenile detention centers in the state of Illinois than we had some 10 years ago, because circuit courts around the state are recognizing the value of restorative justice, which actually is now implemented in Cook County, even though it had been earlier implemented at downstate. So I think that the Supreme Court is actively engaged through its administrative office in identifying restorative justice programs. In the Circuit Court of Cook County, Chief Judge Tim Evans has instigated or implemented an extensive program operating largely on the west side of Chicago in Lawndale. And they operate with peace circles, and they have youth who come in and they take responsibility for the offenses that they have committed in the interest, again, of avoiding incarceration. So I think that the Supreme Court should continue its effort through the administrative office in identifying alternatives to detention for youth. Thank you.
Yeah, so the Supreme Court definitely has a role in restorative justice. And first of all, we should be really proud of what Illinois has done on restorative justice. We have the Restorative Justice Community Court in North Lawndale that takes nonviolent offenders age 26 and lower and puts them into the Restorative Justice Community Court if folks opt into it. That's something to be really proud of, and I'm proud of it in particular because I work with the Lawndale Christian Legal Center, which serves as the restorative justice hub. So I hope everyone is proud of the progress that we've made on that front. However, that progress is at risk, and here's why. peace circles work the following way. You get the offender to come in, you get the victim to opt in, and you get the members of the community to come in. And then you also get a circle keeper who's like a manager of the process. The offender says what they did, the victim talks about how it hurt them, the members of the community talk about how it impacted them, and then you develop a plan for restoration. First and foremost, to restore the victim, second, to restore members of the community, but also to restore the offender themselves. Okay, here's the problem. Here's the good thing, which is that process relies on open and forthcoming communication. Here's the problem. That communication is not privileged. So what that means is things that are said within that circle can be used against people in court, including the victim, by the way. And so all that progress that we've made is at risk if someone says something in that circle that then is used against them in court. Because you have to opt into that program. And so all of a sudden, lawyers will say, don't opt into that, that's a trap. Or opt in, but tell me what you're gonna say before you say it, and so I can make sure that you're being careful, right? Which is against the spirit of the process. In response to that, a large group of a coalition proposed a rule to the Illinois Supreme Court to make those communications privileged, to protect our progress on this stuff. And the Illinois Supreme Court rejected the rule. We need to revisit that rule so that we can protect that progress.
Good evening. I would support the continued role of the Supreme Court in encouraging restorative justice in juvenile court. I think those are the individuals who can be helped the most, the young individuals who committed offenses and can be helped by being guided along in the right path. That is really the best use for it. I don't see any use for it actually in our court itself, on the Supreme Court, because you have to understand that once a case gets to the Supreme Court, someone's already been convicted. There's been a lot of lawyers involved in terms of briefing and arguing, and restorative justice is not going to be applicable there. But I would encourage the use of it to help individuals who may best be lightly touched by the criminal justice system to get on the straight and narrow path.
Yes, I believe you just alluded to portions of this question, but I'd like to ask that you be a bit more specific in what you might do in terms of juvenile offenders. And the question is, what do you believe to be the root causes for the high number of juvenile offenders? And the second part of that question is, what changes can the court system make to reduce these numbers?
So I'm a clinical social worker. My educational background began as a clinical social worker in the state of Maryland, and I worked with a lot of juveniles, some who were abused and neglected, but of course those individuals often wound up in the juvenile justice system as well. I believe that it's a foundational issue, and I think it's an issue of economics as well. So we're dealing with a lot of single family homes, a lot of single parent homes, a lot of joblessness that goes on in a lot of poor, economically underdeveloped communities. I think that's the root. I think there's a foundational crack that all of us as citizens, not necessarily just the court, have a responsibility to try and address. To address those things obviously requires money. Money comes to the judiciary from the legislature. The Supreme Court does not fund itself. The Supreme Court must ask for money for every aspect of its operations from the General Assembly. So I would seek to have dialogue with the General Assembly with respect to managing or overseeing or developing some programs especially designed for aiding children.
Thanks. So I think some of the root causes are a lack of economic opportunity, lack of opportunity, and a vision of their future in some cases. There are some new issues though, and we've seen it here in Evanston where sometimes we see these kind of social media beefs that go back and forth with cliques starting to cause real problems. And that's a new problem that we haven't started to figure out how to address yet, but it's something that we need to realize is a new issue confronting our youth here in Evanston and elsewhere as well. There are things that we can do about it. One of them is start to upscale the amount of restorative justice that we use and that we apply. The other is we already have a provision in the in our Illinois Constitution, Article 1, Section 11, that says we are obligated to restore offenders to useful citizenship. And so that is our existing obligation, and we need to start taking that more seriously. But also there's a lot of ways in which our courts are failing to catch the right people. And so anytime we wrongfully convict someone, we leave someone else on the street, and we need to fix that part.
Thank you.
I was always told that a child needs one thing to really thrive in life, And that's some adult in his life that makes that child feel like everything that child does is the most important thing in the world. And what we're seeing here is that many individuals, many juveniles don't have that adult in their life. And how do we fix that? Well, that's the cause of it. I think that's the cause of it. But how do we fix it? Apparently, we're going to need some type of mentoring effort to the young people who actually find themselves entrapped in the juvenile system. I would be willing to explore how to get that, but really it comes down to children not knowing that someone is looking over them and thinking what they do is important to them. But we have to fix that.
Justice McBride?
I think that the primary reasons for young people being involved in the criminal justice system relates to economic conditions and the lack of education. I don't know if it's a problem we can solve in a day. I also think, though, that gangs have contributed significantly to luring younger children into criminal activity. And in some ways, we're going to have to begin to look at how are we treating those that bring children in to commit crimes, because those children won't be incarcerated, so to speak, for an offense that they commit. So it's a global problem. I don't know that it's going to be solved today or tomorrow, but I do think that I agree with many of the comments made, particularly Justice House and Cobbs and Mr. Epstein.
Okay, the next question is from the Democratic Party of Evanston, and it's 1 minute.
Can you talk about what role does the Supreme Court have in protecting the rights of poor citizens and of those with marginalized identities?
It has a massive role, and it has the role in protecting the rights of all people, but the difference is that we're not doing as good a job in protecting the rights of poor people. In particular, we still have a system of cash bail that puts people in jail simply because they don't have enough cash to buy their way out, right? They're deemed safe to return to the community, they're presumed innocent, but they linger in jail for years because they don't have enough cash. That's the only distinguishing factor. And we have a sitting Supreme Court justice who just the other day said that the reason that we can't end it is because we need the 10% of the D-bond to fund jails. He's not here today. His name is Justice Neville, but that's his opinion. I think that's unacceptable. We need leadership on this, and we need a justice who will say we need to end cash bail now. It's unacceptable. We need to make it so that people have transcripts so that they have a real right to appeal in the first place. We need to allow remote appearances so that people who can't take off work or can't leave their caretaker responsibilities behind can even get to our courts and access them. So there's a huge amount that we can and should be doing, and the Illinois Supreme Court is responsible for it.
Because of my background of being born an underdog, I have a sensitivity to those who are the underdogs in our society. And I believe one of the biggest problems that we have is the high cost of hiring a lawyer. And individuals who come to court can't afford lawyers, and so we have a large number of self-represented litigants. Over half the cases, there's at least one self-represented litigant. The Supreme Court can take a role by making it simpler for people to proceed through the courts, by making the procedures clear, by providing forms that are clear and simple without being full of legalese, and to provide in the future facilitators to show where you file things or what comes next in a case. And I think that's the way we have to be sensitive to it. I am sensitive to it because of my background and my perspective. And that's what I would do as a Supreme Court Justice, to make sure that the courts are navigable by everyone.
I'm on the Access to Justice Commission. I didn't start it, the Supreme Court did a few years ago. They recognized how important it was that the Supreme Court be actively involved in helping people have access to the courts. We're not talking really about criminal cases because for the most part, every criminal defendant actually has the right to an attorney unless they want to have, if they want to proceed by themselves or not. But for civil litigants, there are a lot of people that just don't have access. And I think the Supreme Court has been doing a lot to try to get access to justice for everyone. And a lot of things have to, we really need money to actually get some of these initiatives going, but eviction court, courts involving money owed and custody matters, oftentimes individuals are representing themselves and it's very difficult. But I think that the the Access to Justice Commission has to be expanded, and I think that it's doing a good job, and we need to get better.
Thank you. I agree with Justice McBride. The Supreme Court has been actively engaged now, and you heard Commissioner Suffredin speak with you about the strategic planning that's ongoing now with the Supreme Court. One of the big issues that is a major topic for the court is access to justice, procedural fairness. I serve on the Illinois Supreme Court Judicial College, and it certainly is an initiative that we're undertaking to review and assess. But when I talk about access to justice as one of my major issues or interests, I recognize that having been a trial judge, there are many litigants who come into our courtroom who are not represented by attorneys, either because they can't afford to, or maybe they looked at Google and thought they didn't need to. Well, but when they come in and they're not able to traverse that system, we have an issue and we need to address it. As the director of the Illinois courts, we administer Supreme Court Rule 711, licensing law students to engage in the limited practice of law under the supervision of lawyers. I think that we could continue to utilize them under that supervision and have them work with self-represented litigants so that they have equal access to the court system.
What role should a Supreme Court judge's personal and political ideology play in deciding cases? And when, if ever, is it appropriate for a Supreme Court judge to decide how to rule based solely on his or her personal preference?
Well, here's what my philosophy is. If you're going to become a judge, you do not have any place to ever have your personal or political ideology play in cases, all right? It's really the antithesis of what judicial impartiality is. There was a case, I don't know if you remember, a few years back, where a judge who was of Catholic belief determined that a lesbian couple could not adopt a child. She let her religious beliefs determine the outcome of a case. She was reversed. Judges are supposed to be neutral. They are supposed to be impartial, and they cannot decide cases based on their personal or religious or any other kind of beliefs. We're neutral arbiters.
So I concur with Justice McBride. We take an oath when we ascend the bench, and it is to follow the law and to uphold the laws of the state of Illinois and the Constitution. When you take the robe, when you put on the robe and you take the bench, you must take that being as impartial and unbiased as you can possibly be. Otherwise, litigants end up with very different results depending on who you are as a person or what your religious beliefs are or what your personal preferences are. That's absolutely what we don't want from a judge. We want a judge to see every case clearly and for its facts and based on its facts and the law only. So we don't bring our personal beliefs, our personal feelings. We bring objectivity. We bring the ability to assess credibility, to apply the law and understand the law to a set of facts in every case.
Never.
Oh.
You know, I agree with my colleagues for the most part, but you know, when we look through history, there have been some times when there's been precedents and cases which were immoral and unfair to people. There was a case that said a white man has no respect, that a black man has no rights that a white man has to respect. When a case comes up, and it's, you know, I'm sure it's rare, that is so morally reprehensible to you, I think that you're gonna I would feel compelled to stand up and say this is wrong. And that would be the only extreme example. But other than that, I believe, I agree with my colleagues that we have to leave our personal alone. But when there's a moral issue on the table and it's so violated that it violates everything that in your fiber, you're gonna have to step up.
The next question is Evanston Chamber.
Thank you. I have a bit of a long question, so I'm challenging your listening skills. The Brennan Center for Justice released a report analyzing the composition of state Supreme Court benches. The findings are pretty shocking. 24 states currently have an all-white Supreme Court bench, including 8 states in which people of color are at least a quarter of the state's general population. Only 15% of state Supreme Court seats nationwide are held by individuals who are Black, Asian, Latino, or Native American, though nearly 40% of the nation's population are people of color. Since at least 1960, the earliest year for which we were able to obtain comprehensive data, 13 states have never seated a person of color as a justice, and 6 more states have only had 1 justice of color. More than a third of all states, 18 in total, have never seated a black justice. Women hold only 36% of state Supreme Court seats. Currently, 17 states have only one female justice on their Supreme Court bench. In Illinois, how do we start to make our Supreme Court more reflective of our population?
So thank you for the question, and it resonates with me because I've had an opportunity to read that Brennan report, and I am very much aware of the paucity of African American women who serve on state Supreme Courts. I would note that prior to my running for this office, there were two other African American women who sought to ascend to the Supreme Court, and neither of them were successful. I would be the third. I think that there is a way for the Supreme Court in making its interim appointments to the bench to pay close attention to the demographics in the entire state. So for instance, before an appointment could be made in a downstate circuit, the court should take stock of what that bench looks like. Who's sitting on those benches? What are the number of women? What are the number of men? What are the number of African Americans, Asian Americans? Just take a look at the demographics before then deciding to make that appointment. When I was a director of the Illinois courts, I learned that the court was not collecting that kind of information, and we began to do so in the administrative office, with an eye toward having the court review that material before they would make any appointment, not just to the judiciary, but to all of the several boards, committees, and commissions that serve under the auspices of the court, and who inform the court or advise the court with respect to policy and programs.
Yeah, it gets even deeper. 0 religious minorities on the court, 0 non-senior citizens on the court. Everything I do is about systemic reform, and so what I think is we need to start building the pipeline all the way from the very beginning, and there are certain systems that we can change that are standing in the way of us doing that. So the timing of our character and fitness assessment. You take on a load of debt, you go to law school, you pass the bar, and then you have to pass a character and fitness assessment. And if you don't, you can't become an attorney. And it's kind of a black box problem. And they look at your entire disciplinary record, suspensions and arrests and convictions, and we don't really know how that plays all the time. And so people who are from highly policed communities, for example, might have reason to worry about whether to take on that debt in the first place if they don't know how it's going to end up, whether they're going to be able to join the bar. Changing from career clerks to rotating clerks so that we can start to develop young attorneys and young judges so that we can prepare them for development the way that the federal courts already do in many cases, but in Illinois we don't. There's structural changes we can make.
I believe the diversity in our courts enrich our courts in two ways. First of all, the more viewpoints you get in making decisions, the kind of decisions that the Supreme Court makes, the better and more well-rounded the decision is going to be, because you're going to have different perspectives from the different perspectives feeding into it. And secondly, you know, our courts are respected because we believe things are fair, and people will accept a bad decision, a decision against them if they believe they have been heard. And people lose that confidence when they see that the court is all one culture or one ethnicity. I think we can enrich our courts and get more people on the Supreme Court by having forums like these, by having as mentioned before, by having a background of people who are ready to go to the Supreme Court, by reporting judges. Thank you.
Thank you. Justice McBride.
Yeah, I definitely want to weigh in on this one. I've read the Brennan report. I'm not sure about all the numbers, but I am curious about whether the states that have been, so lacking in diversity are elective states where people elect the judges, or whether they're merit selection. And there's a lot of politics involved with merit selection, but we can't change anything right now because in this state, we elect judges. That's what the Constitution requires. And in order to change our system, we'd need a constitutional amendment. There are many people that feel a merit selection system, could increase diversity. But if I were on the Supreme Court, one of the first things that they have the power to do is appoint judges. And right now, it's like each one gets a turn. I've never been appointed to any position. I've had to run. I was appointed as an associate judge, but it's a system that excludes people. Anyway, I am in the DePaul Law School Advisory Committee. We have a pipeline. DePaul has more diversity than any law school in the state. And we are trying to get law students into the pipeline. We're getting them into courtrooms. We're getting them jobs as clerks.
Thank you, Justice McBride. Thank
Sorry.
you. Okay, and our last question from our panel here, and then I'm going to hit the audience, is Art of Evolution, a work of faith, William Eason.
In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
So the issue of free speech is obviously a constitutional one. We are guided in the determination of any question regarding the Constitution by the language in both the Illinois Constitution and the U.S. Constitution. We're not necessarily required to follow the U.S. Constitution in lockstep when the Illinois Constitution would provide broader protections. So I think that it is the type of issue where we certainly can't talk about how we would rule, but in any case, that raises a constitutional claim, and those facts that are presented in the case, you must look at the facts of the particular case. You must construe the language in the Constitution to determine whether or not there's been a violation. I think that might come close to what you're characterizing as a balancing.
Yeah, this is an issue that my campaign actually deals with. Running as a public servant who has an unambiguously Jewish last name comes with certain risks, and if you look on our social media feed, it gets pretty ugly. You know, there are comments there that are just one word. It just says "kike." That's it. Don't vote for him. He's a Jew. That's it. It's something that we deal with on our social media. It's something that I've dealt with in my life, in the workplace. I've been called that before, and other things. I've been hit at the same time. This is something that I address from an area of personal experience. But even so, I take on the approach from the American Library Association. They said, freedom is a dangerous way of life, but it is ours. And I let that be a guiding principle.
I believe in free speech, but the rights of free speech do not allow you to commit a criminal act against another individual. And that's where I stand on it, if I think I got your question.
I'll sort of echo what Justice House said. If someone commits a hate crime, they need to be prosecuted. If it meets within the standards, you're not going to have a free speech interrupting the prosecution. So if you've got the elements, it's up to the state's attorney to bring those charges and prosecute and get a conviction.
Thank you for the judges who are here. So tonight I heard direct communication about the Illinois judicial system, and then from one of you I heard about children needing mentors and at least one responsible adult in a child's life. I've not heard, I think, about the root of systemic evils like racism and homophobia and sexism that have rooted themselves in the system. There must be, it seems to me, a resounding systematic change in the Illinois judicial system. So how can we know if you are elected that you won't just join the good old boys club, but that you will be an agent of change, and you will be willing to do all you can, including sacrifice, to change the minds of others who are on the bench?
That's my pastor. I knew it was going to come deep. Okay. Who would like to take that one first?
How many seconds do we have? Because I need a whole hour.
Let's do a minute on that one.
We're doing a minute.
We're going to do a minute on that one.
So thank you, Pastor, for your question. I'm a PK. I'm the daughter of a preacher's kid. I'm a preacher's kid, so that part. So in any case, I've never been a part or even accepted as a part of the Good Old Boys Network. As a matter of fact, the Good Old Boys wouldn't even hire me to work in their law firm, and that's with Dean's listing. There were none that would accept an application from me, which is how I fortunately ended up spending 31 to 32 years of my legal career in the court system, which did accept me. So I don't tolerate it. Mr. Epstein talked about some of the nasty things that he's reading on his Facebook post. Believe it or not, so am I. As an African-American woman, I am confronted almost daily with someone who seeks to know why I am running, and am I running simply because I'm a black woman. I don't respond to them because I know I'm a qualified black woman, but I would not tolerate it for one moment. If you bring it to me, you're going to get it back.
Yeah, I think you can trust the fact that I would continue the work of campaigning for systemic reform because, and know that I would sacrifice to do it because I already have. I mean, when I started, first of all, I gave up a job that I loved. I gave up nearly all of my life savings. I put aside enough to maintain health insurance and to buy a ring for my girlfriend, and the rest went into this campaign to cause systemic reform. And when I did it, I have to tell you, I mean, people were giving me advice saying I was literally going to ruin my life. I was getting threats, legitimate threats, for doing this. And we charged forward because it's that important. I mean, as an attorney, I'm the only attorney. I'm the only attorney in this race, and look, I was representing people and being asked to put my feet in their shoes, and what I was seeing them experience was something that I didn't want to continue to do for the next 50 years. And it was that important to me that I left my professional life and my wealth behind to do this. So I'm doing it for the opportunity to cause systemic reform. That's the whole reason I made that sacrifice in the first place. I think you can trust that I'll continue to do it.
I've never been a part of the Good Old Boys Club. I have always, in my career, fought for what I thought was right. In 1990, I was approached by a group of community activists to fight for the Harold Washington Party, which I did. When I was on the appellate court, I didn't go along with things. I saw a problem where people were sitting around with cases 6 months old and a years old, people waiting in jail, waiting to see what would happen. And I've instituted a rule to change things, that if you had such a case, you had to explain it. And so I've never been a person to just accept bad situations and just go along with it. I've always been one trying to do the right thing, and I will do the right thing in the Supreme Court.
I can definitely tell you that I have never been part of the Old Boys Club because I was never slated by the Democratic Party. I've been an independent. I had to run every single time that I've ever tried for anything in the Illinois court system. When I started in the state's attorney's office, there were very few women and there were very few African Americans, and there were very few people that were Hispanic and from the LGBT community. And most of us were, we were at the bottom. We were at the bottom. Things have changed. I will say that Kim Foxx has really changed the office. There are so many women, African American women, that are working in that office. I think a third of her supervisors are women. And so I will bring something different because I simply have never been one of the old boys. I'm not now. And I believe that I will bring diversity, I will bring enthusiasm, hard work, integrity, and that's what I plan to do.
When we see your name on that ballot and we go to vote, what is the one thing each of us need to think when we see your name on that ballot?
I want you to think about what you want from the justice system, whether you want a different justice system tomorrow than the one that we have today. I want you to think about whether you think that the systems we have in place adequately allow courts to find truth and restore people, and if not, to vote for the one person who's proposed those kinds of reforms that would allow our courts to find truth, that would make it so that our courts aren't getting compensated for convictions, that would make it so that we get discovery in criminal cases the way we get it in civil cases. We treat people as good as we treat money. So make it so that we're not jailing people simply because they don't have enough cash to afford bail, to make it so that we're not relying on the honor system to stop judges from deciding cases for their campaign donors. If you want these kinds of changes, I hope you'll think of Daniel Epstein on March 17th. Thanks so much.
Thank you for the sponsors who set this event up. My name is Nathaniel Roosevelt House. I will bring to the bench 43 years of experience, 22 years as a lawyer. And that time as a lawyer was spent arguing tough cases against people who were stacked, where the deck was stacked against them. I argued a case before the Illinois Supreme Court at the age of 40. And those were tough cases. And when I became a judge, I brought the lessons I've learned from my father in terms of diligence to the bench. I brought it to the Supreme Court. I've demonstrated by example by having zero backlog for the last 4 years and leading the entire court. I've eliminated, when I was chair, the over 6 month delay in cases. I want you to remember also that I bring a unique perspective, having been born in the South, gone to segregated schools. I will bring all of that to the benefit of the people of the state of Illinois. So on March 17th, I want you to remember 5 little words. House is in the house. Thank you.
The only thing I want you to remember about me is the way I have lived my judicial life for over 32 years and my professional life before that. Each case is important and each person is important. That's how I've lived my judicial life. That's how justice should be. And I ask you to think of that when you see my name on the ballot.
I want to first of all thank you again for hosting us and for entertaining us and in a minute feeding us. That's really, really great. I want you to remember what the work of the Supreme Court is. Because unless you know and remember what the work of the Supreme Court is, you will likely hire the wrong person. The work of the Supreme Court is to decide cases and to run the court system. I ran the court system for 9.5 years. And yes, I was a trial judge, and yes, I'm an appellate court judge. So I have both the legal competence and the administrative experience to hit the ground running. I know how to get the work of the Supreme Court done because I've done the work of the Supreme Court. It's not new to me. The other thing that I want to stress, and I want you to remember, is the Brennan Center report. We've had some difficulty in electing an African-American woman to the Supreme Court. I am uniquely qualified to serve on the state's high court. And so I don't have a catchy phrase, but remember this. Don't walk out the door before you punch 164. I'm Cynthia Cobbs.
All right, thank you. Thank you, everybody. Thank you. Jennifer Zappos is straight to the back. Enjoy, enjoy. Thank you.